Okay. Good evening and Sawadee krap, everyone. Dear member and guests, welcome to our SPE monthly technical meeting. We hope you are well and healthy during this challenging period. For those who do not know me, my name is Panit Jesadawaranon from Mubadala Petroleum. I'm the Vice Chairperson on this program. Today's meeting is very special. This will be the joint meeting between Association of International Petroleum Negotiators, or AIPN, and SPE Thailand section on the topic of intellectual property overview, what to focus on in the contract and the field. Presenting by Kun Joseph Tomkiewicz and Kun Sher Chua. The presentation itself would take 30 to 40 minutes. Then during the presentation, please put your microphone on mute. If you have any questions, please leave it in the Zoom chat box. And of course, if you prefer to ask in person, please leave the message in the chat box as well. And then we will call your name and you can open your mic for the discussion. Kindly note that this session will be on recorded as well and will be available on the SPE Thailand section website. On our mission and vision, typically we would hold this event in the hotel for social gathering. Unfortunately, in this pandemic, we would hope to do this through online webinar. Having said that, we still continue with our mission to keep you informed of what's going on in our industry and make new knowledge available to you with our monthly technical presentation. Our vision is, of course, is to be open to share information with our peers across the company so we can provide the energy for our kingdom and, of course, meet many new faces. And we also would like to see a smile on your face and hope to see you face-to-face soon. With a similar format, we will start with section announcement, updating you the SPE Thailand status. Then we following by the presentation. And then we have the Q&A section. On SPE Thailand section membership, we have over 500 members, combining of 280 professional and 291 student members from Chulalongkorn, Suratnari, Prince of Songkhla, and Chiang Mai university students. Not only to retain, but our section also gain new professional members since the beginning of the year. However, there's still another 155 professional members from 2020 that has not yet renewed the membership. So may I remind you, please recheck your membership status. And if it lapses, please consider to renew it. Note that you could also consider the e-membership or electronic membership where it is only $20 annual fee to renew your membership. And for us, please also invite a colleague to join our meeting, or even better, join SPE, because we always need new members. SPE Thailand is still the largest professional oil industry organization where you can regularly meet and greet in the relaxed environment. Not now, but later we will. These companies are the sponsors who support us, our Thailand monthly technical meeting for this season. For any of you, you may have just tuned into this meeting. If you would like to see your company logo here, please reach out to us, any of board members. We appreciate your support, and of course, our society needs you. Here are our upcoming SPE Thailand technical meeting So in September, we will have a meeting on the completion topic, single trip completion enabled by conformable sand control system combined with the multitasking valve from Kun Pavini Baker-Hughes. And in October, we will have another joint technical meeting with SPWLA on the topic of a geomechanical model for hydraulic fracture simulation, a rock physics workflow by Kun Ryan from SPWLA. You can also check out other technical meeting or other events in our website as well. So let's hear from our neighbors. So SPWLA, we have the webinar on 26th of August on resolving wellbore stability issue offshore West Madura pre and post drill analysis result by Dr. Fran Mauders. So of course, if you're interested, you can register on the website here. Now, how to reach us? So for SPE Thailand section, we have different channels for social media. You can go through our website, thaispe.org, to find out the upcoming events, new announcement, young professional event or scholarship program, and much more. You can also follow our Facebook by pick up your phone and you can scan the QR code here to join our Facebook, or you can join our LinkedIn group as well for SPE Thailand section on the right. So hope you enjoy our social media. Without further ado, let me now hand over to our program chairperson, Kun Kasian, who will do the honor of introducing our speakers tonight. Thank you.
Okay, thank you very much, Krab Kun Panit, and good evening, everyone. My name is Kasian Sintuong. I'm the SPE Thailand Program Chairperson. Now, we are fortunate to have two speakers for this evening, and it is my honor to do the introduction as always. The first speaker is Kun Joseph Tomkiewicz. He has over 30 years of managerial, transactional, and litigation experience in the world's largest publicly traded oil and gas companies. He has significant experience working with various forms of petroleum agreements and has also negotiated and realized contracts for some of the largest ever industrial constructions. Another speaker, Kun Chua. She is a trusted advisor for commercial and transactional IP matters and has extensive experience handling IP due diligence exercise, audit, acquisitions, licensing, and franchising projects. She was named by the World Trademark Review as a global leader in 2020 as well as 2021, and was highlighted for her practical and tenacious problem-solving ability. She was also ranked in the World IP Review's list of influential women in IP in 2020, and was the first Southeast Asian recipient of the International Trademark Association's highly coveted Tomorrow Leaders Award in 2019. Sher is appointed in the INTA Emerging Issues Committee and served as the director of the Malaysian Thai Chamber of Commerce. Ladies and gentlemen, please welcome our speaker for the joint SPE-AIPN virtual meeting tonight on the topic named An Overview of Intellectual Property, What to Focus on in the Contract and Field. Now over to you, Kun Jo and Kun Sher. You may go ahead and take over the share screen.
Thank you, Kun Kasian and Kun Panit. Some good reminders. I was hoping that SPE would have more of its memberships paid for by this point. So for those of you on the call, I'm sure you've all paid, but reach out to your friends and remind them. SPE, think of this every Thursday night, third Thursday of the night. We would normally meet at the Landmark Hotel in Bangkok to have these sessions. So hopefully we'll get back to that soon, but membership means everything. I couldn't help but notice that the next two technical sessions are very technical. And this is the reason why when I talked to SPE and when I talked to Ronald Tay about this event, I really thought it was important to put some of our messaging out there and to maybe have a review on intellectual property rights. And as you heard, Sher is an expert in this area. And so we put together a slide deck here tonight, or she put together a slide deck and is going to talk about it. That hopefully will trigger some ideas in your head for those of you listening tonight or for those of you watching online. And as you focus on either performance at your companies or in protecting your companies, or regardless of what department you work in, basic intellectual property overview from time to time is going to keep you sharp in this area, just like safety drills, just like reviewing material as we do as part of our regular job functions in law and engineering. And so that's the basis for putting this deck together. I think I'm going to turn this over to Sher now, but I would like to say that Tilleke and Gibbins is a very proud sponsor of SPE. We take our commitment to SPE very seriously, and so if there's anything any of you need, you should feel free to reach out to Sher or I. Our information is on the screen there, or you can contact Kun Kasian or Kun Panit to get in touch with us. But we're looking forward to this tonight, and I'm going to hand this back over to Kun Sher and put my microphone on mute.
Thank you, Joe. Good evening, everyone. My name is Sher, and I'm very happy to be here this evening to talk to you about something that excites me very much. So in the next 40 minutes or so, I will be taking you on a journey where we will take a quick dive into some important aspects of intellectual property. We will first give you an overview of the different types of intellectual property rights. We'll then move on to talk about the monetization of these rights before going on to discuss about some of the common mistakes that we see in terms of IP matters when it comes to joint ventures or strategic collaborations between IP owners. Now, first, let's talk about IP. So when I say IP, what is the first thing that comes to your mind? If you are a musician, you would probably think of the copyright of your music, right? Or if you are a chef, you could be thinking about the recipe of the dish that you just came up with. You could also be thinking about the name of your restaurant. But there are different types of intellectual property rights. On this screen, you will see that I have listed 8 different types of IP rights. For today's purposes, we will only be focusing on the first 4, namely trademarks, copyright, industrial designs, or design patents, as we call it here in Thailand, as well as patents or invention patents. We will first look at trademarks. Now, what exactly are trademarks? Trademarks are source identifiers, right? They tell us the origin of a product, of a service. So it could be a word, it could be a letter of the alphabet, it could be a symbol, or it could be a combination of any of these elements. Now, the same name, the same word can also be used as a trademark of different companies. On this screen, you will see an example of Puma Energy, the energy company, as well as Puma, the sports and fitness brand. Another example that we have included on this slide is the Cafe Amazon example, where you would see the use of Amazon if in a F&B chain, as well as the use of the word Amazon in the tech giant Amazon. So here we can see that trademarks are source identifiers just because that someone has used a certain word, a certain phrase, or a certain term for a particular company doesn't mean that someone else is definitely prohibited from using the same. Copyright. As for the example I gave earlier, so if you are a musician, you would probably think of the copyright of your music. But copyright is more than just music, right? Copyright extends to computer program, so software. It could extend to artworks, books, or this set of presentation, this presentation deck that you're looking at right now. So these are all protected by copyright. Now, previously we looked at trademarks, where trademarks are registrable rights, right? Here in Thailand, you can put in an application at the Thai Department of Intellectual Property, get a certificate issued, and then renew it every 10 years. Copyright is different, right? You do not actually have to put in an application in order to get your copyright protected. Copyright arises automatically. The moment you create it, it exists. So you do not actually have to go to the Thai Department of Intellectual Property to put in an application, but you can do so. So there is a process available where you're able to file a voluntary recordation of your copyright ownership. Now we'll quickly talk about industrial designs or design patterns. Industrial designs protect the ornamental aspects of an article. It protects the aesthetical parts of your invention. So for example, the design of a watch, the design of a luxury handbag, or a Herman Miller chair, or the design of a car, for example. So these are the external appearances of products. Now we want to differentiate this from invention patterns. Invention patterns are what we think of when we think of pharmaceuticals, when we think of vaccines, when we think of new technology. For design patterns and invention patterns, these are all governed under the Patents Act here in Thailand. So you do actually have to go to the Thai Department of Intellectual Property to put in an application to get a patent granted in order to be able to enforce your rights under the Act. One example of a very famous patent here in Thailand is the one that you can see on the lower half of the screen. It's a patent granted to the late King Rama IX. It's called the Chai Patana Arita. And we still see this in public parks across Bangkok, across Thailand today. One fun fact is that King Rama IX is the first leader in the world to have received a Global Leader Award conferred by the World Intellectual Property Organization for the late King's contributions to promoting intellectual property in Thailand and in the world. So for design patterns and for invention patterns, like I mentioned earlier, you do have to put in an application. So you do have to get it granted, and you do have to pay annuities to maintain it. So this is a very brief overview of 4 main types of intellectual property rights. And here we have some examples from the energy industry. I have here an example of a registered trademark belonging to Woodside Energy on the top left corner of the screen. Of course, within the industry, you'll see different types of intellectual property rights. Apart from trademarks, you could have software that would help you optimize your operations, and these are protected under copyright laws. Of course, in certain countries, you may be able to get a patent granted for computer programs, or should I say certain types of software as well. On the right here, I've included a sample patent publication from the US, just to give you an idea of how these sort of patent documents look like. I also want to talk briefly about generating goodwill of your trademarks. for example, through collaborations, for example, through partnering with other third parties, right? I have included here examples from F1 as well as from the NBA, where you can see that different companies have used the goodwill in their brand, in their trademarks, to create or to generate even more value through these valuable partnerships with third parties. So these are examples of commercialization of intellectual property, which we will talk about in the next few slides. On the right, I have included a sample patent document just to also show you that there can be more than one owner of a particular IP right. So in this case, a jointly owned patent between two different entities, namely, I believe it's Petronas and Dalian Institute. Just to give you an idea. Now that we have given you a brief overview of the different types of intellectual property rights, I want to move on to talk about the commercialization of IP rights. So why do we want to commercialize IP? Why do we want to monetize IP? The very obvious reason is so that we can optimize the financial benefits that we can get through our IP assets, right? Because IP assets, they carry value. They are intangible assets, but they carry value. They are unlike your houses, your cars, your cryptocurrencies, but they are still able to hold value and generate even more value. In terms of financial benefits, we think of recouping the investment that we have put in terms of R&D. So every year, energy companies, oil and gas companies spend billions of dollars in R&D. Through the commercialization of these IP rights, you are then able to find a way to recoup some, if not more, of this investment sums that you have spent in R&D. Through the commercialization of IP rights, we're also able to generate revenue through licensing structures. So for example, you have come up with a proprietary technology to optimize, for example, the cleaning of the gas pipelines. Perhaps you do not just want to use it within your own company. You could think of licensing this even to your competitors or even to someone from a different industry and then collect royalties and thereby generating income, generating revenue for your company. Through the commercialization of IP, we are able to also gain access to new technology and markets. Think of a restaurant owner, for example, who is interested in venturing into a new territory. Instead of going there and trying to learn about the market on his own, perhaps he's able to identify a suitable partner that he's then able to grant a license to, perhaps through a franchising structure. And through this process, you are able to then enter into a new jurisdiction, a new market where you previously do not have any presence. And this is particularly important when sometimes we are restricted because of local legal or regulatory restrictions due to certain restrictions that apply to foreign investors. Again, through the commercialization of IP assets, you are able to step into these previously uncharted territories and or industries. The commercialization of IP is also a valuable method for you to think of in terms of a defensive strategy to protect yourselves from potential lawsuits or to protect yourselves from having to spend on frivolous or somewhat unnecessary lawsuits. We have seen a lot of examples, especially in software companies, where they try to identify existing infringers who are using pirated software and getting them to actually obtain a proper license to use the software. Again, through the commercialization of intellectual property. Now, how do we commercialize IP? Of course, the most straightforward way is to do it yourself, right? Directly exploit it, directly monetize it. But you can also think of the assignment of these rights, for example, by selling this new technology, this new invention to an interested purchaser. Or you can also do it through various methods of strategic, collaborative ventures with third parties, through licensing, franchising, through entering into a joint venture partnership. And this could be through forming a new entity where both parties come together and cross-license certain types of IP. Or it could be simply an agreement where you come together and decide to do something together for a fixed period of time. So there are so many ways to commercialize IP, and it's just up to us to find the right method that best suits your present purposes. I have included here an example that I like very much, Star Wars. So about 9 years ago, Walt Disney acquired Lucasfilm for $4 billion US. And through this acquisition process, what Disney has actually done is that it has actually acquired the entire Star Wars franchise. And if you're thinking that $4 billion is a lot of money, think of all the extra money, the extra revenue that Disney is able to generate because of this acquisition. Now, Disney has always been a powerhouse when it comes to licensing, right? We know them for their films, for their cartoon characters and all of this. But we also see the Walt Disney characters in our toys, in our school bags, in our drinks, in our fashion garments, in our food. And all this is done through licensing. On this screen, you will see examples where Disney has had licensing arrangements with, say, Uniqlo, with Nestle, with Ferrero, with Lego. An example of successful licensing. In this slide, I have included other examples of more recent acquisitions that are quite IP focused. This includes Google's acquisition of Fitbit earlier this year, as well as the recent acquisition of Gojek by AirAsia. On this slide, again, some examples that you experts in the industry would be able to relate to very well. So for example, when Chevron acquired Global Energy, we're not just talking about acquiring existing real assets, right? Because through an acquisition like this, you're also looking at the entire IP portfolio that they are able to obtain through this transaction. We're also looking at the talent, the manpower that becomes part of Chevron through this acquisition. And with your human capital comes knowledge. And through knowledge, there is always, always intellectual property. Now that we have talked about commercializing intellectual property, we'll move on to talk about some common mistakes that we see in joint ventures when it comes to IP, as well as some pointers that you need to take note of in these transactions. So imagine that you are a Thai company, a Thai energy company, and you have identified a startup in China that has come up with a new technology where they are able to say that they have created a very good subsea robot, and you want to be able to use this robot as a part of your operations. So you want to approach them, you want to think of, okay, what are the possible options that we can think of to work together. So obviously, in a situation like this, we want to think of what is it that both parties want, right? Obviously, you both want to win. You want clarity. You want clarity in the framework. You want it to be clear as to who is getting what, who is paying what, who will be responsible for what. You want to be able to trust each other. You also want to be sure that you will not be giving up on your valuable IP, but at the same time, you want to have access to the other party's IP. Both parties would also want a fair allocation of liability. And last but not least, a very clear exit plan to the extent possible, right? Because that gives you security. Now, in a structure like this, in a transaction like this, there are always common mutual benefits. For example, from the perspective of business growth, you, the large Thai energy company, is a potential licensee, is a potential buyer, right? How you would benefit from these potential acquisition or licensing arrangement is that you are essentially gaining access to a proven model. That's how that company attracted your attention in the first place, because they have a proven model. That's why you want it to be part of your company. And with a proven model, with a proven product, you minimize risk. You cut down on the potential sums that you have to put into R&D, right? You will also have the comfort of knowing that you'll be able to work with people who already know how this new technology works. So on this slide, you will see a brief comparison when it comes to the common mutual benefits that both parties would have. And you want to keep this in mind at the negotiating table. I also want to talk briefly about where your perspectives would differ in a situation like this. Typically, the IP owner, the licensor, they would want to provide a grant scope of license that is as narrow as possible, right? To limit the potential licensee from using it in too many different ways or in too many different places. The licensor would likely want to only grant a non-exclusive license so that they are able to grant that same license to someone else, perhaps your competitor. Chances are the licensor would also want you, the licensee, who probably knows the local market more than they do, to assist in fighting off potential infringers or to help them to identify infringers. Or when it comes to the costs, they might want the local licensee to bear certain parts of the cost when it comes to enforcement. So there are different perspectives, there are common mutual benefits. These are things that you want to think of, that you want to have on your checklist when you go to the negotiating table. Now, when we talk about a joint venture, and I'm using the word joint venture here very loosely because I'm also referring to any sort of strategic collaborative ventures that you have with a third party. There's always a pre-contract stage where you negotiate, you conduct your audits, you conduct your due diligence process. The actual contracting stage where you come together, draft the agreement and get it signed. Implementation and termination. In the next few slides, we'll talk about pre-contract and the contract stages. So a very important thing, and unfortunately also a very common mistake that we see, is that a lot of parties forget the importance of having a non-disclosure agreement signed. So an NDA or a confidentiality agreement, it is essential You must have it. And I would really recommend that you would already have templates, or at least certain ready letters that you would have within your organization that you can bring to the table from the very beginning, right? Because if you don't have your own template, chances are the counterparty will want to use theirs. And in a situation like this, chances are that it's going to be a unilateral type of NDA where you are required to agree to a lot of things, but they may not be expected to do the same. So at the very least, we want to have mutual obligations in the NDA. In the NDA, you want to keep the wording broad so that so that the other party or its employees, staff, independent contractors are not allowed to use any sort of information that you provide to them for any other purposes other than the purposes that you have explicitly agreed to. Now, remember that you're still at the pre-contractual stage, right? Which means that parties are still negotiating. You're still trying to decide whether or not to do business together. And you want to prevent a situation where after giving them the essential information that they require to make that decision, that they walk away from this deal and then use the information that you have given them to create their own similar product or service offerings. So NDA is very important. Do not skip this step. Another mistake that we usually see is that parties forget to conduct an IP audit. Now, it's always good to include IP audits as part of your organization's IP strategy. You want to carry it out at least once a year. And there are so many good reasons for doing that. On this slide, you will see a non-exhaustive checklist of things that you have to think of when you conduct this IP audit. So this IP audit is basically in place so that you are able to have a good look at your existing IP assets, your existing IP portfolio. Now, if you do not do this annually, at least do it before entering into an important transaction, right? This allows you to think of what exactly are you going to bring into this transaction? What exactly are the IP rights that you are going to contribute to this joint venture? Now, remember, in the example I gave earlier, we said that you are a Thai energy company and you're dealing with a Chinese startup with a technology that you want. A lot of organizations that we have worked with seem to have that misconception that in a situation like this, you are the party that requires their IP. But remember that this actually works both ways. Yes, you do need their technology, their IP in that sense, but this does not mean that you're not bringing any IP to the table, right? Because you have your years of experience, you have your talent, you have your existing portfolio of patents, for example, or even trademarks that carry a lot of goodwill through your years of operation. And all these carry value. So just because that in this particular transaction, the core IP we're looking at is that third-party IP, this doesn't mean that you are not bringing any IP to the table. Just remember this point, which is why this IP audit is important. It gives you the opportunity to think of what exactly are we bringing to the table. And if you are carrying out this process on an annual basis, not on a transaction basis, this also gives you the chance to think of, okay, now we have 300 patents across the world. Are they all still very important to the company? Do we still need to allocate the budget to pay the annuities? Do we still need to keep them renewed? Do we still need to keep them active? Because patents are expensive to obtain, right? And They are less expensive to maintain, but it still costs a lot of money, especially when you have patents granted in many, many different countries, because remember, intellectual property rights are territorial in nature. So when you carry out this IP audit, you get to think of, okay, do I still want to maintain this patent? Because as we know, technology changes so very quickly, right? Something that's relevant 3 or 4 years ago may not be so relevant today. So you want to think of that. And an IP audit allows you to look at this. Now, I also want to talk about IP due diligence. As a part of any M&A transaction or any sort of joint venture, yes, it is common practice to carry out a due diligence process before parties proceed to finalize their terms. But unfortunately, we do see that in many major transactions, the IP bit seems to be forgotten. And you should not forget about IP as part of a due diligence process. Again, on this slide, I have included a non-exhaustive list of things that you have to consider in an IP due diligence. We have seen examples where, and it's a common mistake that we see as well, where a company, so let's just use that example that I had earlier about the Chinese startup. So you've decided that, okay, you want to proceed to sign an agreement with this potential partner. We've seen instances where the company, because they did not carry out an IP due diligence, eventually the party that they have signed that agreement with is not exactly the owner of that particular piece of technology that they want. So for example, if a patent has been applied for, or if a patent has been granted, you want to see if that company that you're contracting with is the actual legal owner, right? In startups, it's common to see that because they might have started the invention process before the company is formed, right? And you want to file that patent as soon as possible before novelty is defeated and you won't get a patent granted. So because of this, the inventors or the founders of the company may go ahead to put in an application for the patent first. And this will be done in their own name. This will not be in the name of the company. So when you eventually sign that agreement with the company, it turns out that, hey, they are not actually the legal owners of that piece of technology that you so badly want. So carry out the IP due diligence process, ensure that you are actually contracting with the IP owner, or if they are not the IP owner, do they actually have the right from that IP owner to enter into these licensing arrangements with you? You would also want to be careful in situations where you have IP rights such as patents that are jointly owned by different companies. For example, that party that you're contracting with actually co-owns this piece of patent with someone else. You want to know if they actually have that right to grant you this sub-license, or do you actually need to get the co-owner who's not part of this transaction to agree to this as well? So this is a very, very important part that you want to think of, right? Another important part of the IP due diligence process that I want to highlight is the territory. One common mistake that we've seen is that parties get so excited to sign that agreement that they do not actually realize that, yes, although these partner owns a patent in their home country, they do not actually have a patent granted in Thailand, for example, where the licensee actually wants to use this technology. Again, the IP diligence process is very, very important. At the very least, you must conduct your IP ownership checks, okay? So do not skip this step. Actually, there are many examples of disasters that we have that we learn of, right, in the past. I'll give you an example where although this does not apply to the energy industry. An example where the IP due diligence process was not carried out properly and therefore created a lot of problems. This was when BMW acquired Rolls-Royce many, many years ago. Because the due diligence process of IP was not done properly, what actually happened was that BMW ended up acquiring the rights to create vehicles that look like Rolls-Royce cars, but they're not able to call them Rolls-Royce because the Rolls-Royce trademark was actually owned by a different entity. So that was very, very expensive to fix, and you want to avoid a situation like this. And therefore, please carry out your IP due diligence. Now that you have completed your pre-contractual processes of your NDA, your IP audits, your IP due diligence, you're ready to sign a contract, right? I will just talk about 5 key points that you want to take note of when you sign, when you draft and when you sign these contracts. Definitions and validity, you want to be clear on that. You want to the extent possible, identify what is the IP that each party is bringing to the table. We have seen agreements drafted in such a way that says that, okay, party A is going to provide the technology that allows them to clean the gas pipelines at a certain level of at a certain speed, whereas party B is going to bring the know-how in optimizing this process. But this is very unclear. What exactly is each party bringing to the table? Are they going to license certain patents? Are they licensing certain know-how? If they are creating a separate joint venture entity together, what is the name that they're going to be using, right? Is it going to be a jointly named entity that incorporates part of each other's trade name? So you want to be clear about that. Do not use very vague terms because that creates problems in the future. Don't forget about trade secrets and confidential information. We know that it's normal to not be able to identify each and every piece of IP that we are licensing. Although as lawyers, we're always very tempted to be able to do that, right? But we know that practically it's not possible. But define this, include clear definitions. And I want to also just give you a practical tip that it may be difficult to prove transfer of knowledge, transfer of technology in certain ways. But one way to do that is, for example, to issue certificates to the staff that attend your training sessions. So for example, when there's a tech transfer, when you are licensing your technology to a third party, chances are you would have to carry out a training program for members of their staff, right? So take photographs, issue certificates, get them to countersign, get them to sign confidentiality agreements as well. Get them to promise that they're not going to use this outside of the scope of this agreement. So make sure that you have things like this in place. Confirmation that the licensor or the seller actually owns the IP. We talked about that earlier, but you want to include that in the agreement as well. Also in the contract, you want to talk about the grant of rights and the restrictions. You want to be very clear about this. Be clear as to how and where can the licensee actually use the IP rights that you are granting to them. And can they use it forever and ever and ever? Or are you only going to allow them to use it for a fixed period? And what's going to happen after the agreement ends, after the joint venture ends? You want to think about that as well. The last bullet point here on new IP rights, I want to touch on that a little bit more. This is very important. Although in a joint venture or a collaborative venture where both parties come together and license their own IP rights, in that process of collaborating, you will have new IP rights created, whether intentionally or unintentionally. So you want to address these IP rights as well. So of course, not all of these IP rights are registrable, right? We can't always be able to file a patent for something. But there could also be what we call know-how or negative know-how. For example, in the process of doing this, you realize that, hey, we have discovered a way to not do something. That itself is know-how. That itself is potentially a trade secret, right? So you want to address what can each party do with this sort of knowledge that they have obtained from this venture. Now, when it comes to new IP rights or resulting IP rights from a venture, parties may agree to co-own them. We want to own these rights together. Parties may also decide that, no, if we are able to show that you contributed 80% to this, then you will get full ownership of it, something like this. One common method to address this is to establish like an IP committee, and you want to have clear language in the agreement to establish a committee like this. So whenever you have an internal IP dispute on an IP related matter, you would then go to this committee. Usually you will have representatives from each party. You can also include independent experts that both parties mutually agree to appoint to make these sort of decisions. This committee can also assist in deciding if they should go ahead to file a patent for a new invention, for example. Payments and royalties. In a licensing structure, you want to think of how do you optimize your gains from this process. Do you want to collect a lump sum fee? Do you want to collect royalties every quarter, every month, or a combination of both? Usually we would see that parties would want a combination of both. You may also want to think of how do you want to value your IP. There are many valuation models out there. Two common ones are listed on this slide, which is the market approach, as well as the revenue generation potential approach. So typically you work with accountants or financial analysts or IP valuers to assign a value to your IP rights if you do not know the value of your portfolio yet. So parties would also want to think of the maintenance or prosecution of new IP rights. As we mentioned earlier, you would have to, it's recommended for you to have a committee to assist you in this process, but you also want to decide, right? So who pays for what? Because like I mentioned earlier, it's especially when it comes to patents, it is an expensive process to obtain a patent. So are parties going to pay equal sums? Who gets to decide which patent attorney that you would go to in the case of co-ownership? These are things that you want to think of. Or what happens if party A decides that they do not want to keep that patent anymore, but party B still wants to maintain that patent? In that contract, to the extent possible, make it clear. You would also want to think of further commercialization rights beyond your current contract, right? So for example, I'm going to go back to the example of the Thai energy company and a Chinese tech startup. So maybe you decide to come together to incorporate this subsea robot to your operations. Perhaps in this process, you realize that there is a potential for you to actually use this in a different industry. For example, in the medical device industry. In a situation like this, how are parties going to agree on commercialization efforts? usually what we'll see is a broadly worded clause that says that, okay, in a situation like this, parties will, in good faith, negotiate further commercialization arrangements and enter into a separate agreement. But at the very least, include something like this so that in case the relationship turns bad, you do not have a party that actually, just walks away with a new invention or a new use for an existing invention that both parties created together. We also have your control. In licensing structures, you would always want to have clear control structures to the extent possible. Auditing rights, inspection rights, how do you maintain the image? This is especially important when creating a joint venture where you're using part of your name in that new entity. Or if you are just simply licensing the use of a trademark, right, to a third party, you would want to be able to exercise these sort of controls. So what are the penalties if someone underpays or underreports their revenues and therefore pay you lesser royalties than you actually deserve? What are the penalties applicable? You want to think of that. You want to include that in the contract as well. The last two bullet points here are basically including clear control measures that prevent your existing or your potential partner or licensee from challenging your existing portfolio or from trying to claim rights to your existing portfolio that you're licensing to them. Termination. We want to think of the best way to have a peaceful breakup in case things don't work out, right? You want to think of, in case of termination, what do you want the other party to do? What do you want your licensee to do? Do you want them to dispose of whatever materials that you've given them? Do you want them to return it? Do you want them to destroy it? You also want to think of a right of first refusal in case someone decides that they no longer want to be a part of this venture. Do you want to have the right of first refusal to acquire their business or acquire their assets or to acquire their existing customer list in a particular territory? You want to think of things like this. One thing that I want to talk about is that appointed representative clause. Again, in certain countries, there may be foreign investment restrictions where you're not able to just directly step in and take over the business, right? So you want to include wordings in your contract stating that it's either you or your appointed representative who's able to take over a lease or take over the assets or take over the business in that territory. Make sure that you include that. Okay. And I think this brings us to the end of our presentation for today. And that's just a very brief overview of, well, IP rights, commercialization, as well as some of the common mistakes that we see and what are the things that you have to consider when entering into a IP transaction. So we're happy to take questions if you have any.
Great, Sher, Hann. I think Frank Timmons, our good friend from Boyden, has a question in the chat room here. So if you can pull that up down below, you could look at it or I'll read it out, which says a question concerning product design IP. Assume a Thai company has an IP agreement to utilize the design of a common item such as a chair. If the chair design IP is not registered in Thailand or elsewhere, can the chair designer enforce the IP agreement in Thailand? So Frank, that's your question. Sir Hann, do you have an answer?
Okay, so here we're talking about the design of a chair. We're saying that assuming that a Thai company has an agreement to utilize the design, and an IP agreement with who? So I'm going to assume that okay, I'm just going to make some assumptions here, yeah? I'll assume that this Thai company has previously entered into an agreement with, say a designer of a chair, and this designer did not actually get any sort of IP registered for this chair. Can this Thai company then proceed to, say, manufacture chairs that look like these chairs after the termination or expiry of this agreement? Based on these assumptions, no, you cannot, because in that agreement itself, chances are there should already be things in place that prevent you from doing so. So even if they do not have IP registered, it could still potentially be a breach of contract. Another thing that we want to think of is that even though you do not have registered IP rights, you still have the tort of passing off. Where if you are able to show that, where if a IP owner is able to show that he or she has obtained, has built goodwill in a particular mark or a design, and that you have used, you through your use has created a misrepresentation that there was some sort of association between you two, and through these misrepresentation, the IP owner has actually suffered some sort of damage from your actions, then he or she will be able to claim through the tort of passing off, and you will still be deemed liable. So I hope that answers your question.
Thanks for that, Frank. How about if we hand this back to Khun Panit, but I'd like to thank Sher, and again, on behalf of the firm of Tilleke and Gibbins, IP search, NDAs, IP due diligence, you really can't hand that off to an engineer in the office and say, hey, get this done. It requires a little more expertise and some legal understanding of these documents. So reach out to us, reach out to your lawyers. There's always a good lawyer around you can get engaged to help you with this. But thanks again for SPE for letting us bring a little bit of legal education to the SPE during the course of the year. So Khun Panit, we hand it back to you and we thank you again. Thanks, Ron. Or Khun Kasian, if you'd like to shut us down. I'm not sure if we hear you, Khun Panit.
Yeah, we can hear you. So nothing much really, just thanks everyone for participating. It has been very interesting topic and new for us, especially from people who on the technical side. So hope you find them useful and see you next month. Thank you very much.
Thank you very much, everyone. See you next month.